Hey Casey, are you able to hear me okay?
Hi, Lindsay. It's Stephanie. I can hear you.
Thanks.
Ms. Weisenthal, are you ready to go? Good afternoon. We're now on the record. It's 3 p.m. on Thursday, April 10th, 2025. This is the pre-hearing conference and proceeding number 23A-0633G. The application of Black Hills, Colorado Gas Incorporated for approval of its 2024 to 2028 Clean Heat Plan. By decision C-25-0262, the commission recognized the need to schedule this pre-hearing conference for additional process in this proceeding after rejecting in part Black Hills' RRR application to approve the settlement agreement. If we could start with party appearances, that'd be great. Black Hills.
Good afternoon, Chairman Blink, Commissioner Plant, Commissioner Gilman, Emmanuel Koshin, representing Black Hills, Colorado Gas, and I cannot seem to turn on my camera, but I will keep working on it.
Thank you. Trial staff.
Yes, thank you, Chair. Chair, Commissioners, Assistant Attorney General Ross Smith, on behalf of staff, I'm joined by my co-counsel today, Assistant Attorney General Josh Foreman.
Thank you, sir. UCA.
Good afternoon, all. This is Tom Dixon, appearing on behalf of the Utility Consumer Advocate's Office, and I'm also with the Colorado Attorney General's Office.
Thank you. CEO.
Good afternoon, everybody. This is Senior Assistant Attorney General David Banis on behalf of CEO, and I'm here with my co-counsel, Jessica Lowry.
Welcome. Sweep.
Good afternoon, Commissioners. Michael Hyatt with Earth Justice, appearing on behalf of SWEEP.
Thank you. Commission Counsel.
Good afternoon, Chair Lindsay Dundas of your Commission Counsel, Assistant Attorney General.
Thank you. Did I miss anyone? With that, I guess I'd like to utilize our time with the parties today to set an evidentiary hearing date or dates and a procedural schedule for the remainder of the proceeding. So I'll throw out a suggestion and then turn it over to my colleagues for their thoughts. For me, I'd propose that the final corrections to the testimony, the witness list, and the cross-examination matrix all be due by May 29th. I then suggest that we have a remote hearing on June 5th to 6th, which may be the only workable dates for us, given the three major hearings we have with Excel this summer. For me, as I see this process, we're basically holding a hearing on the existing record and not trying to create a new record more than a year after initial filing. I'm not sure my colleagues agree. So, Commissioner Gilman, thoughts on the hearing date and my suggestion to limit the hearing to the existing record.
Sorry, so you're suggesting to limit the hearing to the existing record and not have a additional hearing date?
No, I am suggesting additional hearing dates of June 5th and June 6th, but I'm not suggesting we take on whatever new testimony.
Except to the extent, Chair, that hearing exhibits would be admitted through cross at hearing.
Correct.
Okay, so would you have no additional written testimony then prior to the hearing?
Correct.
Yeah, I'm just curious, maybe Ms. Dundas's thoughts on that, if anyone wanted to revise or submit new testimony, if they would be allowed to do so.
Thank you, Commissioners. I think it's up to your discretion ultimately. So typically in a proceeding, there's a deadline for answer testimony, a deadline for rebuttal testimony, and then a final deadline for corrections. Which I believe Chair Blank was saying corrections would be allowed pursuant to standard practice by that May 29th date. What the chair is explaining, I think, is that he sees it as valuable to take the proceeding up exactly as it was before the settlement. So no additional discovery, no amended answer or rebuttal testimony. And I think that's consistent with what the company had in mind in its RRR. think it makes some sense to me to take the proceeding up exactly as it was, but that also doesn't acknowledge the fact that the testimony in this case is, upwards of 10 months old, that some amendments might be appropriate because of that, and that also parties may want the benefit of acknowledging some of the statements from the commissioners that they've been making in this proceeding recently. So again, I see both paths as defensible, additional testimony or not, but that should be decided here at the pre-hearing conference.
Is it appropriate to hear from the parties at all? I mean, it makes no sense to kind of set deadlines for this testimony if no one's planning on or interested in filing testimony. So I have
absolutely.
the horse here to like, is anyone even interested in?
Yeah. Let's do that. Let's go through the parties and see where they're at.
And I'd also just remind the chair that we've got 2 hours. Hopefully this doesn't take that long, but we can also do breakout rooms, take breaks, so the parties can discuss amongst themselves as well.
I think like to the extent it's helpful though, yes, June 5th and 6th are currently open. So like if that helps guide some of the discussion around if people would submit written testimony, perhaps like keeping those dates in mind and hearing feedback on those as well as part of this discussion could be helpful, as they just might guide the overall timeline to some degree.
Commissioner Plant, do you have anything to add, or should we just hear from the parties?
No, so far sounds good. Love to hear from the parties in terms of the testimony question, but the 5th and 6th work for me as well.
Black Hills, I can see you now, Mr. Koshin. Welcome.
Thank you. So in terms of the dates, I believe those dates would work for Black Hills. In terms of filing additional information, to be honest, I'm not sure. Rebuttal was filed so long ago that I'm not sure what it says and what would need to be updated. I think if we do hearing on June 5th and 6th, it may be difficult to have several rounds of testimony filed over the course of the next 2 months. So that might be problematic. I would note that on some level, there's still this fundamental issue, and it was referenced in the commission decision issued on Tuesday about legal issues that need to be addressed. And there's a fundamental question of whether the commission can order a gas-only utility to electrify. And my fear is that we go through this process over the next several months, and another decision comes out that might result in R similar to the one filed this time, with that legal issue not resolved. And my concern is kind of the spinning of wheels in this proceeding. I would note that the company in its rebuttal did agree to file its next clean heat plan around February 2027, so less than 2 years away. The company would argue that it might be more appropriate to allow the electrification process to run through the PSCO channels and allow public service to run with it first. And in less than 2 years, we would be filing another clean heat plan.
That to me. Staff.
Thank you, Chair. As far as the dates are concerned, I think the dates, I think they would work. I would say that in addition to the record and testimony question, I can say with a decent amount of confidence that staff does not really intend on or is really, staff stands by the testimony that was filed. It stands by the settlement that was reached by the parties. It stands by the positions that it took at that time. I think that in terms of, I don't disagree with the company that I think this is a fundamental legal question that's been raised by the commission, both in its order and its deliberation, to the extent that the commissioners are interested in addressing that legal question here in this proceeding. And I'm not going to make a comment on whether that's appropriate or not. I think that, frankly, that question likely should be answered before we can really continue, because I can certainly foresee a situation such as Mr. Koshin was describing, where we end up in the exact same position 8-9 months from now that we're in right now. And I think for staff's part, it's concerned that every moment we delay now on this proceeding is another moment that we're not actually effectuating any of the goals of the clean heat plan. The goals of the clean heat plan are to reduce emissions. So the longer we're deliberating this, the longer that's not happening. So I think that's where staff's concern really comes from here. I understand that the commission might not agree with that, but I think that we also have, I mean, there's another issue even lurking in there of there's a lot of settlement testimony that's on the record. Are we going to strike that from the record? I mean, it seems to me that there's procedurally, we're in a position where I'm not quite sure what the hearing would even be about, frankly. And so I'm trying to thread the needle here for my client. But for now, I will just say that staff is not really intending on filing additional testimony. I mean, that's just where we're at.
UCA.
Thank you, Your Honor. A couple things. First of all, I believe the record as it exists is what we should use, that it is inappropriate to have further testimony provided. If the case had gone to hearing, that's what we have been in hearing in, using that testimony. So from my perspective, the witnesses that provided testimony should be subjected to cross-examination, and that should be the case. With regard to the legal issue, if you wish to have that briefed in advance, I think that would be appropriate. On the other hand, obviously, that's much broader than Black Hills. Atmos Energy and Colorado Natural Gas or gas utilities and might want to weigh in and should have that opportunity. That's not to say that fundamental issue being resolved one way or another wouldn't be helpful. It's just more a question of how they have a role in that. And to the extent the commission wanted to address it, I think it would be appropriate to allow those two entities to intervene and participate in such a briefing if that becomes a possibility. As for the settlement is rejected by the company. And I don't believe it's rejected the entire settlement. It has taken issue with several terms. So a vast majority of this settlement agreement is approved, has been acceptable, and is not at issue. So we have some very limited issues to be addressing in hearing. And that's why I suggest, again, the record should be used as it existed, that new evidence would not be appropriate. That wouldn't have happened had we not reached the settlement agreement, and that we should take into account that we're only taking issue with what has been modified in the settlement agreement, and the rest of it that everybody agreed with should stand. And so that would be our position from UCA.
CEO.
Thank you, Chair. Regarding timing, we're checking our calendars right now. Do you mind if Sweep goes ahead of us? And hopefully I can have an answer for you about timing in the next couple minutes.
Sure. And just before the end of our time together, if you could let us know. Do you have a
Chair,
position?
if you're willing to wait on that, then I can talk about the rest of our thoughts.
Yeah, if you could.
Cool. I think we agree with much of what we've heard right here. It's not entirely clear to us what the hearing is going to be about. We do think that there are valuable suggestions that came up during the settlement process that would artificially almost be ignored if we weren't allowed to, put them before you all, before you go to hearing. The thermal pilot feasibility study is just one of them off the top of my head. It's something that wasn't in anyone's testimony, but it came up during settlement testimony. And we would love if that would be something you all could consider to be able to provide testimony, get that on the record, among other things. If the legal issue here is going to, be something you're going to be deliberating on, I think we should all have the opportunity to brief that. I think we've said in other places that we think that belongs in a M docket. We think that belongs maybe in a different proceeding, but if you're going to do it here, I think we need to have the opportunity to brief the legal issue. And I'm just looking at my notes here. I think that's the highlight of our thoughts on this. It looks like I just got a note from the client that we cannot do those dates. Just about everyone in CEO is out that week.
Mr. Hyatt.
Thank you. As far as dates, maybe it's a moot point now, but those hearing dates would work for Sweep. I think we generally agree that the record is sufficient to move forward, and reach a decision. Taking the existing record as it is, I think would help promptly resolve this case, which we're very much in favor of. And if we do have any additional testimony, I think this June hearing dates would be infeasible because we need discovery, arguably another round testimony response. So I think if we want to keep the June hearing dates, we have to move and proceed on the existing record. We'll also echo what we've heard from other parties, to the extent the primary or one of the primary issues here are legal claims, legal issues. Agree with most of what I've heard so far, and just add that this evidentiary hearing process is really not an ideal way to resolve those legal issues, and would agree there could be value in having a separate briefing process to resolve those legal issues. And then I'd echo, I think, a little bit of what staff and UCA have noted as far as what would this hearing be about. We've heard the commissioners' deliberations on the settlement. We've heard some interest in certain issues. It's hard to go back in time before those discussions, kind of unring the bell from what we've heard. And as UCA noted, I think in their view, this would be a hearing on the limited issues the commission raised in its deliberations on exceptions in RRR. I think we could support that. It would be a much more efficient process, but I think all the parties would have to be clear on exactly what the scope of this hearing is. And is there going to be deliberations on somewhat maybe arguably new issues like the issue of clean heat funding for gas equipment or gas DSM. So I think we just have questions about the scope of the evidentiary hearing process. We want to make sure we're all on the same page.
Well, Commissioner Gilman, I mean, for me personally, I'm not inclined to, well, go ahead. What would you like to say?
No, I mean, it sounds, fairly overwhelmingly like there's not maybe a need for additional testimony or any intent to file additional testimony. I think what I'm trying to figure out is, should we hold some sort of process for briefs around the core legal questions here? Like, is this the appropriate forum to do that? If not, I'm not sure how we make much progress going forward with some of the questions or issues that follow that. And I agree with some of what I heard today. I think there would be a real benefit in going forth and kind of actually hashing out that question. So I don't know if we want to talk to Ms. Dundas here or offline. But that's what I'm trying to figure out, is should there be some briefing around those legal issues so that we can actually address them?
So I think it's really gonna, well, Mr. Dixon, and then I want to, before I turn it to you, Ms. Dundas, I want to turn it back to Commissioner Plant. But Mr. Dixon, do you have a comment to make?
A suggestion. I think we just need oral argument. I mean, writing briefs and putting all this together is just going to take time. I think we can get up on there, do oral argument like we're trained to do, and resolve it in a few hours, at least present the arguments and give it to you to decide on. I could argue it right now, for example, but I'm not suggesting that. But I think oral argument is sufficient and is timely.
Well, I mean, I'm really concerned we don't have the right parties in front of us, and I'm probably closer to Mr. Koshin, which is, let's see the results of a $400 million Excel program, and then, which is funded across both a combined electric and gas system, and then take the lessons learned and apply them to the smaller gas utilities, which would avoid the need to resolve this issue in this case, which I think doesn't have the right parties in front of us. But I'll go to Mr. Smith. Did you have something you wanted to say, or did you put down your hand?
No, I just had one. I am not offering to do oral testimony right now. Don't worry. I don't think I'm ready.
We're not accepting.
I'm not ready for. I'm not ready for that.
Impressive as he is, but yeah, we're not doing that.
I wanted to just an idea, a suggestion that is potentially for the commission's consideration is. Perhaps there is a way to thread the needle of saying we can let the provisions of the settlement that exist go into effect to kind of get this data, and then sort of have a separate thing going on with briefing, and if that's in this proceeding or not, I'm not really going to argue about whether I think there are notice issues with some of these other parties that the other parties have identified here, but I think that maybe there is a way that we can make some progress now, but also try to grant some certainty in the future. And I don't know practically what that looks like, but I'm just saying that maybe there's a middle ground here somewhere.
Mr. Banas?
Thank you, Chair. Well, just in case I haven't said it clearly, we agree with you. We don't think we have the right parties here to be arguing the legal issue. So I just wanted to make that really explicit. And I'm with Mr. Dixon. We could argue it right now. I think that'd be fun. But I do think that typically, if you're going to have an oral argument in hearing, you brief the issues first. You brief the issues first, right? You have written briefs first, and then you have oral argument.
Yeah, we're not gonna we'll figure out the details of that later,
Great.
and we're not gonna have oral argument on this
Okay.
issue now.
So then my question, and just two more questions for you all, is just please clarify what the scope of the issues are. And number one, and number two, is the settlement testimony in the record still, or is that just sort of wiped clean? And if it is in the record, let's all agree what elements of the settlement remain in effect and what are being thrown out. So thanks.
I mean, I think my sense from this discussion is that the full settlement agreement testimony would be on the record, but the settlement would be completely open for wherever it ends up. Mr. Koshin.
So just wanted to state that I agree with what I've been hearing so far. I believe that the right parties to that discussion, that legal issue, are not all in this proceeding. You've got other gas-only utilities that the answer to that question will impact them. And there's two potential outcomes. One is a due process concern. If the commission makes a decision here that gas utilities must, in fact, electrify their gas-only customers, and that is implemented upon ATMIS or CNG, there is a due process issue. The flip side is if there's a policy decision that impacts Black Hills but doesn't impact or is not implemented the same way against ATMIS and CNG, then there's a question of whether or not the commission's policies are equally implemented against similarly situated utilities, which I think is also problematic. Again, I think the right approach is to deal with this issue, this kind of fundamental legal question, either through a miscellaneous proceeding, through a rulemaking where appropriate notice is issued, and those who are impacted by the potential outcome have the opportunity to intervene, have the opportunity to provide input to the commission.
Mr. Hyatt. Oh, you're still on mute.
Apologies. I'd like to go on the record, just taking a dissenting view. I think it is proper to make the legal decision in this case. This is Black Hills Clean Heat Plan. There's a fundamental legal issue about how you interpret the clean heat statute as applies to Black Hills Clean Heat Plan. And if you can't decide that legal issue in this case, I think it's improper to delay a decision on that and have some type of different type of proceeding. We bring on all the gas utilities. Relatedly, I think we saw in Piesco's Clean Heat Plan proceeding, the commission did in that case make a similar kind of broad-based legal ruling on what are clean heat resources. So I think we have precedent for making these types of legal decisions in the context of the utility-specific clean heat plan.
Commissioner Plant, I think you're going to decide this. For me, I'd prefer to wait and see and get further with the public service company clean heat plan before we even go down this path of resolving the legal issues and trying to, forcing beneficial electrification by a utility that doesn't want to do it. So that's where I'm leaning now on a fairly complete record.
Sure.
Go ahead. And I think Commissioner Gilman probably disagrees with that. And I guess Ms. Dundas, if you want to say anything before we hear from Commissioner Plant, that'd be great.
Yeah, thanks, Chair. I guess I'm unclear. I understand that there's there's unresolved evidentiary questions here as well as unresolved legal questions. Pausing on the legal question discussion, my understanding was that from the company's R filing was that if the commission did not essentially retract its entire exceptions decision and put the settlement back in force, then it had provided notice it left the settlement. So if that is the case, then as the case stands right now, there's the entirety of the application unresolved as evidentiary issues. And that was my understanding as to what the additional hearing would be, so that the commission could deliberate on the case and have a complete and final decision on this application. However, if that understanding is incorrect about what parts or if at all Black Hills left the settlement, it would be helpful to know.
Mr. Koshin, if you have any clarity. I don't know that there was 2 votes for a way forward other than more. I mean, there were 3 votes for more process, but I don't know that there were 2 votes for any specific substantive outcome. But if you would clarify where the company is at on the settlement agreement, that might be helpful.
So the company is equally confused. Obviously, the company would support the settlement agreement and would love to see the settlement agreement move forward. Ultimately, the modifications that were made to the settlement agreement were substantive enough that it impacted the company's position with respect to the settlement itself. And so I don't know that we've had an opportunity to go in and say, all right, which pieces are still good and which pieces need to be addressed in a subsequent hearing. As part of the settlement process, there are a lot of gives and takes. I don't know that any party that was a signatory to the settlement was happy with the outcome. They were comfortable with the outcome. And so by modifying it, there might be some parties that are happier than others. And so there might be a need for us to go back and look at the rebuttal testimony as compared to the settlement and figure out what process going forward makes the most sense, other than going back to, and that might be a question, can the settlement agreement be refiled and motion for reconsideration be filed to adopt it? This is the only proceeding I've ever been in where we're kind of discussing this after the fact type scenario.
Same, Mr. Koshin, to that last point, but the commission's decision says the unmodified settlement agreement is not in the public interest. So therefore, as my understanding, the commission was planning on having an evidentiary hearing and then deliberating each issue presented by the company's application made back in August or sometime in 2023. So that's where I believed we were at. The record would stand as it was, and you would have an evidentiary hearing, get your questions answered, and then deliberate on the entirety of the application, just as if you had rejected the settlement and heard the case en banc. And that was under the understanding that if those 2 main modifications made on exceptions were not retracted, the company was leaving the settlement agreement, the unmodified settlement agreements. So that's my understanding of where we were from the commission's decision. And I think Mr. Koshin's perhaps nodding his head that that's what he read as well.
Commissioner Gilman, do you have any last thoughts before we turn this over to Commissioner Plant?
I mean, I'm happy to hear from Commissioner Plant. I'd anticipate it would be beneficial to go kind of offline with Ms. Dundas and conversations before we really finalize anything today, but interested to hear from Commissioner Plant.
Yeah, and Commissioner Plant, if you'd like to talk to Ms. Dundas offline,
Yeah, I mean,
carve out that space for you.
I think we can do that. I mean, it is a little confusing because there was a substantial number of issues that were addressed in the settlement, and I think that the commission modified 2, and the company withdrew. So I don't know if there's the opportunity for the settling parties to resubmit a modified settlement for the purposes of this hearing prior to the hearing that people agree on, and then we could address the remaining issues and what that does in terms of any kind of any kind of additional testimony. I wouldn't think we would need it because they're really the same issues that were taken up in the last hearing anyway. But I don't know if that's an option.
So I guess there's a threshold issue for me, Commissioner Plant. I'm not interested, based on the record, from what I know on the record in front of us now, in trying to order require beneficial electrification for this utility at this time. So I would not brief these issues I would not brief these legal issues, and I would wait until the next filing in February of 2027, which once we're further along with Excel, and once we
Is that going
have
to resolve the
a
legal?
case at the beginning.
Will that resolve the
No,
legal
but I'm
issue?
concerned. No, but I'm concerned it's not going to get resolved in this case anyway. So, and I think Commissioner Gilman wants to have these issues resolved. And if it's the intent of both of you to try and order force beneficial electrification in this case, it's a very different process than if we don't.
Chair, that's going to deliberations
So-
of the ultimate proceeding here. My understanding is the commission ordered BE as a modification to the settlement agreement. With the settlement agreement no longer in place, all the issues are at play. So now we're talking about deliberations of one issue in isolation of the rest of the case. And we're here in a pre-hearing conference and not a deliberations meeting.
Now I understand that, but there's now we're now trying to resolve a legal issue with not all the parties in this case at a very advanced stage of the process. So it seems to me it is a threshold issue.
I think maybe a 15-minute break to check in with each of you would be best at this point.
All right, I'm good with that.
Are we going to
do you
breakout
want-
rooms or taking a break?
I think I'll call you each. For the other AGs on the phone, they're aware that our emails are down, so don't email me. But I will call each commissioner and perhaps we could go off the record for the next 15 minutes.
Yeah, and will you start with Commissioner Plant? I'd suggest.
You're calling on my phone, right? Okay, I'll go find my phone. I'll be ready in a minute.
All right, we're going off the record and we're taking at least a 15-minute break.
Thank you.
All right, Ms. Weisenthal, we're back on the record. I guess my proposal, after conferring with council and with a plea to CEO, is to so we'll go forward with the evidence we have in the record, including the settlement agreement testimony. Other than corrections, we won't expand the record. We'll, if Mr. Brownus, if you could see if you can make the 5th and 6th work, that would be enormously appreciated. I think we're just out of hearing dates, so with some apologies and some pleading, if you could see if you can make that work, that'd be
Chair, when
great.
would you like to know by?
As soon as possible. And we'll see if we can look at alternatives too. There may be some dates, the 26th and 27th of June that may work, although they're really problematic for
I
us.
apologize. I just got a text saying we cannot make that work.
All right, we'll have to look for other dates on our end. Mr. Mendelson, you had some other dates in June that were really problematic for me, but why don't we throw that out with, to the parties?
Yeah, hello, Chair. I believe we were looking at the 26th and 27th of June, or perhaps the end of July. I think the same date's on July.
Chair, just to level set here with the parties a little bit, make sure we're all having the same conversation. I think it's the commission's understanding that the settlement agreement is, or excuse me, the commission's decision determined that the unmodified settlement agreement is not in the public interest. Therefore, the company has left the settlement agreement and the case would be taken up off the record as it stands. So the scope of the proceeding would be, the scope of the hearing would be the entirety of the proceeding. But I've also heard from the parties that there may not be much interest in further litigation of some of these issues. So perhaps we talk to the parties about whether they need 2 days, 1 day, or what before determining a date.
That'd be helpful too. And the other thing is, if we could do any briefing would be at the statement of positions. We would not do oral argument, nor would we try and pre-brief anything until after the case.
We're discussing an evidentiary hearing date, so that's relevant to witness availability, not necessarily. There would be no oral argument on the dates we're discussing.
Mr. Bonas?
Are you suggesting there'd be still cross-examination of witnesses and we'd put on our case? So I see you nodding yes. And what concerns me is that when we put on witnesses at hearing for cross-examination, the very first question I ask after their name is, would your testimony today be the same as what you filed? And I got to tell you, the answer is going to be no for our witness. And he's going to need some direct examination at the hearing.
So, Mr. Banas, are you suggesting you would want a deadline for modified answer testimony prior to an evidentiary hearing?
Yeah, I'm not sure how you characterize it, but some kind of testimony, yes. Modified answer, or modified cross answer, however you want to.
I mean, if we're looking at the end of June, anyway, then it seems like we could probably find the time, to have that.
Mr. Hyatt?
Wanted to jump in and add, while you're looking at dates, sweeps and primary witness is not available June 26th and 27th. So apologies for that.
Mr. Koshin?
Thank you, Chairman Blank. The company is also struggling with the end of June. If it makes sense, it might be helpful to allow the parties the opportunity to review rebuttal as compared to settlement, see what issues are outstanding, see what issues may need to be addressed, see what might be required for an evidentiary hearing itself. My recollection was we did request 3 days of an evidentiary hearing when we initially filed the case or when the initial procedural schedule was adopted. It sounds like we want to go less than 2, potentially even to 1. As an example, it might be helpful to either redo another pre-hearing conference in about a week once we've had an opportunity to review all that, and maybe even discuss with the parties whether additional testimony needs to be filed, what that additional testimony might look like, what that cadence might be, and if the commission can either give us some proposed dates over the next several months, or we can reach out to Ms. Dundas with potential outcomes that might work for all the parties.
I think that's a helpful suggestion. If the parties can narrow the scope, that'd be great. And Ms. Dundas, if you want to work with the attorneys to see if we can find some dates, that'd be great. Mr. Smith.
Thank you, Chair. So I think where I'm I'm struggling with a lot here on this, but I think there was a statement made that the settlement testimony that's been filed in this record is staying on the record. But we're also going back, we're supposed to go back in time before settlement. And so when we get to hearing, it's entirely possible that settlement, I mean, to me, it seems like if we're not going to add to the record, then cross-examination would be adding to the record. If we're not going to expand the record, that would be expanding the record.
No, I mean, my proposal was not to take additional pre-filed written testimony, not to limit the record. You know, of course, cross-examination would add to the record. It was my proposal was to limit the pre-filed testimony, but I don't even know if that's sensible in light of what Mr. Bonas said.
Okay, thank you.
Mr. Koshin.
A follow-up question, would the commission entertain a motion to approve the settlement agreement as filed on August 16th? I think the argument can be made that while it's not a perfect outcome, rejection is not in the public interest, simply because it means we're already in April. Emissions reductions for 2025 are likely out of the question at this point. And if we go to hearing, it just becomes that much worse. I again, respectfully would request that the commission open a miscellaneous docket to address the issues that are kind of forming in this proceeding with the parties that are appropriate for that proceeding. And I believe that approach would likely resolve all the issues that we're dealing with here. Again, the company is filing in its next clean heat plan, February 2027, so less than 2 years out.
I mean, I don't think the settlement agreement had a second vote. I was hoping through this hearing there could be relatively straightforward modifications that could attract a second vote, but I don't know. Mr. Dixon.
Well, and the goal of trying to reach compromise and be realistic, I would think the commission wants to get this program going forward, period. That would be the first assumption I have. Secondly, there are two issues that have been raised in this proceeding. One having to do with demand side management and the other one having to do with the substantial beneficial electrification. I understand Ms. Dundas' statement that the commission has found the agreement as a whole on a permanent basis is against the public interest. However, I think the commission, in the effort to try and move this case along and to get this plan in effect, could find that on a temporary basis for some period of time, the settlement agreement as drafted could be approved, not with any prejudice to the arguments that have been raised for or against the two major issues, and therefore get this thing moving and potentially get the other cases that you've discussed, something, so to speak, behind us so that these issues can be addressed. So to me, it's not like saying it's a public interest for a temporary period and set it for just that it's got 6 months or whatever you think you need to really look at these issues as you proposed on an interim basis and make it that the public interest being the majority of this plan is in the public interest. And these two issues should not be used to delay implementing the good issues. So on a temporary basis, the commission approves it with the understanding that it'll address these two issues in the future or other issues in the future. Just an effort to get it moving.
I mean, I can turn it over to Commissioner Gilman or Commissioner Plan. If there was an earlier filing date of the next plan, maybe even before February 2027, would that help you with this settlement agreement? I mean,
I'll just caveat this discussion. This is a hypothetical discussion of a motion not before you at the moment.
yeah, but we've already deliberated twice on a settlement agreement. I've never seen anything like this in 30 years of doing this. I don't know. Commissioner Gilman, Commissioner Plant, where are you guys?
I mean, I don't know if we have any indication the company would be able to file a second clean heat plan before the time it's already committed to. You know, and I think we'd still need to really find the venue to brief some of the base legal and technical issues that the company made the entire foundation of their RRR. Those issues are squarely before the commission. They were presented by the company in this proceeding. So I don't think we move to another clean heat plan more quickly without settling those issues, you know, could in any way kind of benefit the process.
Mr. Smith.
Thank you, Chair. Just a couple of things. First, I would support Mr. Koshin's motion statement, whatever we're going to call it now, on approving the settlement agreement. I'll just state that whether we want to refile it as a new settlement agreement, however we want to do it. I would also support Mr. Dixon's idea if we could get some more specificity to it. I would also just like to raise that there's been some references to the company's commitment to file the next clean heat plan, and I believe that is a term of the settlement agreement. So that might present a bit of an issue there. And then the final thing I'll just raise is that if we continue forward down this path, staff would like to at least determine whether the commission would be willing to allow staff to either withdraw its settlement testimony or strike the settlement testimony that's been presented by all of the parties from this record.
Mr. Banas. You're on mute, sir.
You'd think I'd have that mastered. CEO would echo what Mr. Smith just said. I mean, we'd support both Mr. Koshin's motion, and in the alternative, we would support Mr. Dixon's motion for all the reasons said. I won't belabor it, but I just wanted to weigh in. Thanks.
Mr. Hyatt.
Thank you. I'll just respond. Not surprisingly, SWEEP opposes any motion to approve the settlement. Like, the commission is deliberating this twice. Finds not in the public interest. This attempt to have a third bite at the apple, we strongly oppose for all the reasons that we've put on the record already. Second, Mr. Dixon's proposal of allowing the other terms of the settlement agreement to move temporarily forward while we focus on the two outstanding issues, I think to me could represent a promising path. And I see the issue here is the company's position that if the commission does not approve the full entire settlement agreement, then it wants to go back and relitigate all the issues. If we could get an agreement here that we're going to just relitigate two issues we've been talking about, it would be a much, I think, more efficient and cleaner process to move forward.
Mr. Koshin.
Absolutely. So again, part of the settlement process is there's a number of gives and takes, and I'll give you one example. RNG, I think in our rebuttal, there was a $3.4 million, some amount that was directed towards RNG, renewable natural gas, that as part of the settlement, the company agreed to substantially reduce it. And so it begs the question of, when you eliminate the gives and the takes that each party negotiated piece by piece, it's hard to come in and say, absolutely, it's just one issue. In the context of this case, eliminating gas from the DSM program or any gas DSM programs from the clean heat substantially reduces the emissions. The costs change. The outcome is very different than what was proposed as part of the settlement. And then when you add electrification, we've made the arguments. We don't believe that it's appropriate in terms of the statutory basis, but also for a company like Black Hills, where Black Hills Colorado Gas has 0 electric customers. To us, it's equivalent to requiring Public Service Company of Colorado to provide telephones to each one of their low-income customers. Is there a basis for that? No. It's equivalent to the state requiring Pizza Hut to serve salad because it's in the public interest that more people eat salad. Again, here, Black Hills Colorado Gas provides gas service. Modifying the settlement the way it was modified does change the final outcome and eliminates some of the balance that was achieved through that settlement process.
Ms. Dundas, I don't know what to do. I think my preference would be to look at dates and bring this back next Wednesday.
I think Mr. Cochin just summarized why we're at a place where the entire application needs to be adjudicated, since the commission has found that the settlement agreement is not in the public interest. All issues would be on the table. However, if the parties have agreement on other issues and would want to present another agreement, I don't see what prevents them from presenting that to the commission. Parties are always free to file motions as they see fit in the proceeding. So it's still my understanding from the commission's prior decision that the unmodified settlement was not in the public interest, and therefore the case reverts back to where it was on rebuttal, and we need an evidentiary hearing to complete deliberations in this proceeding. Now, I also hear from the parties that there would be value to briefing in that evidentiary, or excuse me, in the remainder of this proceeding, and that probably makes some sense. So where I think we're at today is with that, if that is the commission's understanding, what I've just laid out, then asking the parties to file or to come back with some sort of procedural schedule that accommodates that based on what they think would be needed to complete this proceeding.
Comments? Mr. Smith?
So sorry. Yeah, I would also, this is going to sound a little strange. I've never really done this. If staff were to make an oral motion for motion for determination of law by the commission, is that something the commission would be willing to entertain?
Right now?
Sure.
That's what it is. But I'm not looking forward to it.
I mean, I would say that seems to be where we're at this point. I do recognize and appreciate the commission and Ms. Dundas for you explaining that we could potentially still file some form of an agreement, at least to maybe try to, because I'm really struggling with what an evidentiary deliberation would look like right now. But I appreciate that that might be where we're at.
Anybody else? Mr. Bonas? You're still on mute.
I got it.
You're not learning, sir.
I would just ask that if I like Ms. Dundas' suggestion. I would just ask that y'all make it very clear what it is we're doing, what the issues are, what the hearing's about, and what we're going to be briefing, right? And what we're going to be talking about at the hearing. And I think we need direction to know all of that, and then we can go from there.
Commissioner Plant.
Thanks. So just so I understand, I mean, my understanding of the rehearing process is that it goes back to basically the application and all of the documents that have been submitted in the evidentiary record become a part of the evidentiary record. and it's just a rehearing of the case. So, if that's not correct, tell me if that's not correct. I mean, I understand that there's a whole other process that's happened in the last hearing, but my understanding is that in the rehearing process, it's just basically another evidentiary hearing. Is that right?
That was my preference, but what I'm hearing from Mr. Banas and Mr. Smith is that they want the opportunity to change their answer testimony, which would force the company, which would require the company to file rebuttal testimony. So it sounds like they're not interested in moving forward based on the prior testimony, which I mean, basically, it's going to get us pretty close to, I don't know where we're at. I mean, we're going to refile, Black Hill's going to refile a direct case. Mr. Smith?
Is there,
Yes,
I'm
sir.
sorry. Is there
I'm
an
sorry.
issue with them filing rebuttal if we do have the time between now and whenever we can schedule one of these things?
Mr. Smith, I don't know.
Just to be clear, Chair, staff is not interested in changing its answer testimony. The issue is settlement testimony because, as I stated from the outset, like staff's position coming into this today was that we were going to stand by the provisions that were agreed to as part of that settlement agreement, which understandably was found not in the public interest. But some form of that we think still could be.
Oh, so that would simplify things. So you could just resubmit or withdrawal or strike through your settlement testimony, which would not require, if you want, which would not require additional rebuttal testimony. Am I understanding you right, Mr. Smith and Mr. Bonas?
Correct. I believe that's correct. I think the issue that we were facing was that if we were going to go back into rebuttal, then having that settlement testimony on the record may confuse the record. I think that was our concern.
Oh, that makes sense to me. Does that work for you, Mr. Bonas and Ms. Dundas? So maybe we would just withdraw all the settlement testimony.
Chair, I agree with Mr. Smith. That makes sense. I mean, it doesn't make sense to have testimony about something that doesn't exist out there, right?
Okay. All right. So Commissioner Plan, I guess the idea is we're gonna go back to the rebuttal testimony. That'll stand as it is. The settlement testimony will be viewed as stricken or withdrawn, and we'll go to an evidentiary hearing as soon as we can find dates.
That makes sense to me.
Ms. Dundas?
Yeah, Chair, I believe that was the original proposal, so I think we are where we started. So looking for dates for that evidentiary hearing on the entirety of the record as it stood at rebuttal.
All right. I guess, Ms. Dundas, you'll work with the commissioners and council to find some dates.
Yes, so we're looking for dates for an evidentiary hearing with no additional process except for so we'll set a deadline for pre-hearing motions, witness lists, corrections to testimony, a deadline for hearing, and then a deadline for SOPs, and perhaps legal briefing after that evidentiary hearing. That's the schedule that it sounds like everyone's agreeing is necessary for additional process here.
Yep. And any briefing will be in the statement of positions.
Or by the same deadline as the statement of positions, yeah.
Yeah. Mr. Mendelson? Oh, sorry, Ms. Dundas.
I think Mr. Mendelson will probably talk dates if I had to guess.
Yeah, that's right. Thank you. I just wanted to offer the parties that July 24th and 25th does work for the commission. So that is something, if you could consider that as part of your procedural schedule discussions.
Hold on, let me just check. Commissioner Gilman, does that work for you?
It does, yeah, and I don't know if our intent is to settle it right here or to make sure Ms. Dundas and Mr. Mendelson have an accurate set of dates to kind of interface with the parties, but yes, July 24th, 25th works for me.
Does that work for you, Commissioner Plant?
Yes, it does.
Okay, so I'll have Mr. Mendelson
Just-
or I will follow up with the parties with some proposal dates, and then we will, what the commission's ordering here is the parties to file some sort of consensus proposal that takes those dates into consideration. Does that work?
Yeah, can you just give me 2 seconds? All right, it looks like those days work for me.
We could also look into May if there's no additional testimony coming prior, but that's me thinking out loud, so.
All right, anything else for today? Mr. Smith?
I'm so sorry. I don't like talking this much. I hate to even praise this, but should we also include a settlement deadline in this new procedural schedule?
And you're welcome to. I can't imagine there's gonna be a settlement.
We're gonna probably need to find a date before we do that, right?
Yeah,
But, yeah.
Thank you.
Mr. Bonas?
Thank you. Just to be clear, Mr. Hay may still be slightly changing his testimony at this hearing. We haven't gotten that far yet. I didn't want you to be surprised by that. We haven't committed to that.
Understood.
Thank
And all the attorneys don't have to say the same thing.
I just felt
Mr.
obligated. I didn't want to have implied that.
Mr. Dixon?
Just clarifying, July 24, 25 is what we're looking at, or is that tentative or in for the hearing?
I think that it works for the 3 commissioners. It's not clear if it works for the parties.
Thank you.
Mr. Bonas?
Those dates are fine for CEO. If we're taking a poll right now.
Well, we might as well, Mr. Hyatt.
Those dates should work for sweep. And I just wanted to raise Mr. Banis's comment that Mr. Hay might change his testimony. The extent parties are going to change their testimony and stand, I think that's not an ideal situation at all for parties to be able to prepare for a hearing or cross-examine other parties. So I guess I'd oppose that recommendation. And if the party's going to want to change their testimony, they should be doing it through pre-filed written testimony, which I'm not advocating for, but that would be preferable than taking new positions live on the stand.
Mr. Dixon? Mr. Cushion?
Those dates do not work for Black Hills. Our consultant is not available.
All right, we'll take it up offline. Ms. Dundas, anything else before we adjourn?
No, Chair, I think what the resolution of this hearing is that there will be an evidentiary hearing in this proceeding. The commission's agreed to take the record as a stand after rebuttal. We are looking for 2 dates, which Mr. Mendelson and I will follow up with proposal dates, and then the company will file something in the proceeding for the commission to adjudicate on for the remainder of the evidentiary process out of CWO.
And we'll try and limit any changes to the testimony as much as possible. And the briefing will be in the statement of positions. So
do you want to take a vote on that? And then let's say maybe 7 days from the receipt of the proposed dates to the parties that they file that proposed consensus procedural schedule.
Commissioner Gilman?
Yeah, that works for me.
Commissioner Plant?
Yep.
Works for me. Ms. Dundas, anything up? Mr. Bonas?
Thank you. Will there be a written order so that we can wrap our heads around everything here? We've been taking notes frantically, but I'm
Ms.
not sure if we
Dundas?
succeeded.
Yeah, I think that we can provide a written order based on the commissioner's last vote, which was a vote to have an evidentiary hearing on the scope of the application, to order the parties to file a consensus procedural schedule for the remainder of this proceeding, which includes a 2-day evidentiary hearing. It will include a deadline for SOPs / legal briefing if necessary. And that would be the contents of that filing. That'll come in 7 days from, let's say, tomorrow, when Mr. Mendelson and I give them a little bit more unofficial guidance on dates that would work for the commissioners.
Thank you.
Would it also note that the settlement testimony has been stricken?
Yes, I think it would, Commissioner Goman,
Yes.
Commissioner Plant.
Yes.
Thank you.
Good with that too, and I think it can be an ABC order, Ms. Dundas.
Okay.
And let's discourage changes, but maybe not forbid them. All right, anything else for today, Commissioner Gilman?
No, nothing additional. Thanks.
Commissioner Plant?
No, thanks.
Anything from the parties? Thanks all.
Thank you.
Thank you.
Chair, are we off the record now?
Yeah. Oh, I guess did I need to say something before we go off the record, Ms. Dundas?
Nope, just that we'll memorialize it with the written order, and for the court reporter that we're off the record.
We're off the record. Thanks all.
Thank you.
Thank you.